The case against televangelist Timothy Omotoso has been adjourned until tomorrow. Omotoso appeared in the East London Regional Court on charges related to the contravention of the Immigration Act following his arrest on Saturday at East London CBD. Now, immigration officer from Home Affairs Department Obrim Funzana testified in court that Omotoso does not possess a valid visa and has no pending application thereof. He said Omotoso's temporary visa application was rejected in 2017 as his documents were not in line with the visa application requirements. Meanwhile, defense lawyer advocate Sakela Poswa argued that Omotoso's arrest was premature and his rights were infringed. He said his client was supposed to be afforded 10 days to appeal the decision for deportation after receiving the letter from the Home Affairs Department. All right, now joining us to discuss Pastor Timothy Omotoso's rearrest is immigration lawyer Carly Kane. Good evening, Carly. Thank you very much for joining us on the late edition. Now, the scenes today outside court where the pastor was appearing and the words exchanged give a clear indication that there are differing views on this latest arrest. Omotoso's supporters believe he's now being persecuted, while others believe he should have actually been long deported as per the initial statement after his acquittal that he would be deported back to Nigeria. But these are, of course, utterances of laymen. What is the process as per the legal prescripts in such a case?
Hi, Mpunda. Thank you so much for having me. Yes, I think that this is quite a polarizing matter, and I think it's important to keep a distinction between the legal procedures and, of course, what people's emotions, obviously bring to the foreground. Now, being declared a prohibited person is a very serious administrative declaration that Home Affairs can make against a foreign national. And essentially what this is where somebody is found to have either been in possession of fraudulent documentation, to have misrepresented themselves to the department, or where somebody has been who has a warrant issued against them or a conviction of a list of offences, including human trafficking, torture, genocide, things like that. Now, the Department of Home Affairs, of course, must follow their set internal procedures. They must properly investigate a case where somebody is suspected to have contravened the Immigration Act. And so where a declaration of prohibition has been made, it would stand to reason that that's been done after a significant investigation and proper procedure is followed.
Now, Omotoso's legal representative, though, maintains that the arrest was premature, if anything, and that his rights were in fact infringed upon. He should have been given at the very least 10 days to appeal the decision for deportation. What does the law provide for in that respect? Do you have the 10 days to appeal or not?
Well, yes. I mean, the proper procedure has to have been followed. Of course, I mean, I don't know exactly the facts of this particular matter and when documents were delivered or what documents were delivered, because a person must keep in mind that the Immigration Act, while it is not the most voluminous act amongst our legislation, it is quite varied. And so a person can be declared prohibited, they can be declared undesirable. These things can also happen simultaneously. An applicant, the Immigration Act provides that where a decision is made adversely against a foreign national, they have a right to appeal. And so I would hope that the proper procedures have been followed on both sides by both the department and by the foreign nationals' representatives.
Pardon me for interjecting, just in the interest of clarity. You spoke about the prohibited individual and the undesirable individual, and we've heard both terms. Are they used interchangeably, or there is a clear distinction?
No, there's a clear distinction. Certainly, amongst lay people, they may be used interchangeably, but legally they are very different things. An undesirable person most commonly is somebody who has overstayed their visa. And a prohibited person specifically refers to somebody who has either misrepresented themselves or documentation, presented fraudulent documentation, so a fraudulent visa, passport, ID document, or who has a conviction or a warrant for one of the list of offences listed, which is torture, genocide, human trafficking, drug-related offences. So undesirability, there are a few other circumstances where one can be declared undesirable, but the most common is where somebody overstays their visa, sometimes by a day, sometimes by a decade.
Now, Carly, though the details around this specific matter are still scant, and as the court proceedings continue to become more clearer, what exactly are the issues here? But in the case of Pastor Timothy Omotoso, when he was incarcerated and, of course, accused of the human trafficking and the sexual offences, in that instance, when one is found, could he have been declared a prohibited individual then, while he was incarcerated, because that's our understanding in 2017, and now beyond the outcome where he has been acquitted, would he have recourse to say you took the decision based on the circumstances that were before you then, but now that I have been acquitted, it is only fair that this decision be reversed?
Well, that would be on the assumption that the declaration of prohibition was based on these charges specifically. You know, we don't have that information at hand at the moment, but that declaration could have been based on other factors by the department. So if I'm not incorrect in saying that the department alleges that the foreign national in this situation has not had a valid visa since 2017. If that is the case, then he has, you know, he's been illegally present in the country for almost 8 years. Again, I don't know the facts. I don't know whether he traveled out and obtained new visitors' visas. I'm not sure. But in terms of the principle of it, the declaration of prohibition may have been based on something else. Or alternatively, like the Act says, a declaration of prohibition can be made where a warrant is issued against someone for one of these offences.
All right.
A warrant or a conviction. So there really are a lot of intricacies relating to the Immigration Act. You know, the Immigration Act leans heavily on administrative law, and it's important to distinguish the administrative law from the criminal law. The two things can run in tandem.
Right. Carly, thank you very much for your insights this evening. That's immigration lawyer Carly Kane speaking to us there.